an illegal worker here, whatever visa they come here on, we will enforce a law against them.
Government Bill. This Council resumes the second reading debate on the Employment Amendment Bill 2025. Honourable Mrs. Regina Ip, Chairman of the Bills Committee on the Bill, will first address the Council on the committee's report. Mrs. Ip. Thank you, President. In my capacity as the Chairman of the Bills Committee on the Employment Amendment Bill 2025, I report to the Council the salient points of the deliberations of the committee. The bill seeks to revise the working hours threshold of the continuous contract requirement under the Employment Ordinance to lower the weekly working hours threshold from 18 hours to 17 hours and provide an alternative of using the total working hours in 4 weeks as a counting unit, in that if the total working hours of that week and the 3 weeks before that week reaches 68 hours, a week with less than 17 working hours will be counted towards a continuous employment period. This is called the new requirement. The bill also provides for transitional arrangements. The Bills Committee has held one meeting to have focused scrutiny of the policy and the provisions. Members in general supported the bill. During the scrutiny, members have expressed a concern that under the new requirement, some employers might devise certain work arrangements to circumvent the provision of additional protection and benefits. They have suggested to the administration that a mechanism be set up to prevent circumvention and that a review on the requirements under continuous contract be conducted at the right time in order to protect the rights of employees. The administration has indicated that the new requirement would significantly increase the cost and operational difficulties for employers to circumvent the continuous contract requirement. The vast majority of employers will make proper work arrangements according to the actual operational needs. Some members pointed out that amid the current unfavorable economic environment and labor shortage, the new requirement would increase the operating pressure on some employers. The impact on micro and SMEs would be particularly obvious. They have suggested that the administration monitor the operation of these enterprises in the 6 months after the implementation of the new requirement and provide support to them as needed. According to the administration, there would be a limited impact on enterprises, so there was no plan to provide cash subsidies to enterprises for the time being. Nevertheless, it would monitor labor relations. Many employees, in particular the grassroots, do not have sufficient knowledge of the continuous contract requirement and related employment benefits. Members have asked the administration to step up publicity, such as distribution of information leaflets at workplace of elementary workers, work with district women's groups to enhance their awareness of the new requirement. The administration has indicated that they would make good use of existing platforms and networks, such as the industry-based tripartite committees, human resources managers clubs, trade unions, and chambers of commerce, to carry out extensive publicity to ensure that employers and employees are aware of the new arrangements. It has also taken note of members' suggestions about publicity channels and would follow up. Besides, it would develop simple tools to help employers and employees understand the new requirement. President, I now express my own views on the bill. When I first came into contact with this subject, it was a request for assistance from women who worked with who go out to work alongside their husband. They said that the original requirements are too rigid. They are unable to enjoy the additional statutory benefits, say, for example, maternity leave, sickness allowance, etc. So I do welcome this new requirement, that is, to use 60 hours over 4 weeks as the counting unit. This will provide flexibility to single parent families who are working, or in fact in households where both parents are working. In restaurants, most people are working on a casual basis. Some questions were asked as to whether they were afforded the relevant protection. Back then, government officials said that in restaurants and hotels there were clear records, so no one will be left out. But I hear that there is fierce competition amongst delivery workers. They have lodged some complaints because there is this mechanism when they have to try to compete for an order. 10% of the orders are up for grabs. These delivery workers work on different platforms or they are working for themselves. If they have to compete for orders, how do you suppose to calculate their work hours? I have made the suggestion in the scrutiny that more explanation should be given to grassroots women. In addition, ethnic minorities, especially those working on a casual basis or working as delivery workers, should receive more information. In my constituency, there are a lot of such delivery workers. If necessary, please, I will make arrangements for you to have briefing sessions or help you distribute leaflets so that the information will be effectively disseminated.
Mr. Chen Su-hong, President, I speak in support of the Employment Amendment Bill 2025. I support its second and third reading. Since its establishment in 1968, we already had the 418 requirement. If a employee is continuously employed by employer for 4 weeks and each week they are working for 18 hours or more, one would be seen as being continuous employment, and they are entitled to statutory employee rights. The 418 requirement is to ensure there is stable employment, and when one is in continuous employment, one should be given statutory rights, but these would not cover part-time or casual workers. So we also had a small number of employers circumventing the relevant requirement. They would try to fluctuate the working hours of employees to circumvent the threshold for calculation of work hours, so that the hours would be cut for a particular week to less than 18 hours. So even though the total number of working hours for a worker would be close to a full-time employee's working hours, they would not be entitled to the statutory employee rights. And there are 3 major amendments to be made. One, lowering the weekly working hours threshold from 18 hours to 17 hours. To provide an alternative of using the aggregate working hours in 4 weeks as a counting unit, in which a week with less than 17 working hours be counted towards a continuous employment period if the sum of the working hours of that week and those of the 3 weeks immediately preceding that week reaches 68 hours. And this is the proposed 468 requirement. The loophole of the 418 requirement would have employers circumventing the loophole by cutting hours in a particular week. With the proposed amendments in the bill, there should be better protection for employees as intended. I do know some of those in the business sector are worried that employers in future need to provide additional employee benefits, as that would cause a burden on micro, small, and medium-sized enterprises, MSMEs. And the administration advised it is roughly estimated that if the 418 requirement is relaxed, the number of employees to be benefited would approximately be 11,400, with an overall potential additional annual cost on businesses of around $0.15 billion, representing only 0.02% of the total payroll expenditure in Hong Kong, which would be a limited impact on enterprises. But I think the administration is only taking it from a macro perspective. For MSMEs, some of them at least will be burdened. But I also think the 418 requirement being relaxed would not automatically grant the workers with the statutory maternity leave and other allowances if it is only after one is employed for more than 12 consecutive months that they would be entitled to relevant leave. And for allowances, one should be working for at least 5 months. And for maternity leave, one should be employed for at least 40 consecutive weeks. So if one is employed by an employer for more than 12 months, this should be seen as stable employment. And it is not wrong to have them granted with statutory employee rights. In fact, if we enhance employee protection with this, it should enhance motivation of such employees, and that would reduce wastage. And there are also some who are worried that full-time workers would want to take advantage of the new arrangement and take up multiple part-time jobs and therefore entitled to the different rights and allowances. And some members have also asked about this during the bill's committee deliberations. In fact, the administration advised that according to the findings of a thematic household survey published by the Census and Statistics Department in June 2019, on the desire of economically inactive persons to take up jobs, out of some 100,000 economically inactive persons, and it is said 63% of them would consider the hours to be a major factor. And for the 61,000 people who are female home workers aged 30 to 59 and the 15,600 early retirees indicated they would be willing to take up jobs if being offered suitable employment. We don't have specific information whether these people would indeed take up jobs with the relaxation of the requirement, but I think it can be an incentive. The proposed amendments will increase the cost of employers trying to circumvent the requirement, but we cannot fully prevent such from happening. We need to make sure employers will comply with the requirement, because if they think they may profit from it, they may try to circumvent the requirement. We need to understand that some companies are more flexible to engage part-time and casual workers, but then due to the nature of certain businesses, companies may be more inclined to hire part-time and casual workers. We have some who are probably not aware of the requirement, especially MSMEs. And Section 1(2) of the bill said that the bill is to come into operation on the first Sunday 6 months after the gazettal of the bill. And we have in this bill two major amendments: lowering of the hourly weekly working hours threshold and an alternative counting method. We need to enhance publicity to make sure employers understand the latest requirements. I also understand that the administration will go through existing platforms of the tripartite industrial committees as well as human resource managers clubs to enhance awareness of stakeholders. I think apart from having pamphlets or guidelines, the government should consider having some programs for calculation of the relevant periods so as to facilitate businesses. We have in the services industry, more of those who are not employed with continuous contracts at the moment. So these industries are going to be affected more. So I think the government should enhance liaison with MSMEs in these industries. And 6 months after the bill's provisions come into operation, there should be review on whether more support measures should be given. Thank you. Mr. Lam Chen Sing. The relevant provisions in the employment ordinance were originally established to provide better protection for those who are engaged for longer hours by employers, but we have seen employers cutting hours of employees so as to circumvent the relevant requirement. We have seen workers being assigned very long working hours for the first 3 weeks, and the last week they would have assigned 17 hours. And they are not seen as full-time employees. With the new amendments, we have, with the previous provisions, we have not seen the provisions function as intended. I do appreciate the government heeding the feedback of various labor organizations, introducing the relevant amendments and lowering the weekly working hours threshold from 18 to 17 hours and introducing an alternative calculation method so that more of those working longer hours are more likely to be entitled to statutory employee rights. And if one can only work for 67 hours in future, one would not be entitled to the relevant rights. I have no comment about this. I have no problem with the 4-week period working hours threshold being 68 hours. I understand why the threshold is set at that, but I am concerned with people working for over 100 hours. They would not be entitled to such benefits. But I think with the proposed amendments, this loophole can be plugged. But can it be plugged fully is another issue. We have one working for 2 hours in a particular month, and then the next month they will only work for 67 hours in the next month. So on average, they would be working over 68 hours, but then they cannot be entitled to the relevant employee rights. So I asked during the Bills Committee meeting with Section 2A1B1 for the 3 weeks next preceding the week for one to be employed by the employer. If one is working for 68 hours, one should be entitled to statutory employee rights. So for the first week, they would work for 17 hours. For second to the 4th week, they would be working 67 hours. For the 5th week, they would only work 0 hours. And then if they have a cycle of 67 hours thereafter, this continuous contract would not be valid, so the employee would not be entitled to the statutory employee rights. Why didn't we try to include the period for the week or the 3 weeks after the week also? That was the question I asked. And the administration advised that with the two calculation approaches both included, there will be different combinations of calculating such requirement. There is an inconsistency of calculation results. I do understand the administration's reply, but I hope the government will consider reviewing the operations after implementation of the bill's provisions And if necessary, we should have the calculation approach include the period of 3 weeks immediately following the week so as to plug the loophole fully, and that more people who are working longer hours will be entitled to the statutory employee rights. Some employers express concern that the operating costs will increase. And I think the intent of the proposed amendments is to provide better coverage for those working longer hours. And if an employer is engaging a worker for 100 odd hours, these are long hours, but the small number of employers are circumventing the requirement. And this should not be seen as an increase of operating costs of enterprises. It is just because they are given the benefit of lower costs and they are only paying reasonable pay to employees now. And for one, before the amendments of the bill are introduced, they are only working 17 hours per week, but then if they're working 4 consecutive weeks, each week 17 hours, they will now be entitled to the statutory employee rights. And for those who have worked for less than 68 hours and they are given the cut after the commencement of the bill, it is the employer circumventing the relevant requirement. And we have now, with the amendments in the bill, an alternative calculation method for a 4-week period. As long as the sum of the working hours reaches 68 hours, one would be entitled to the statutory employee rights. And the various policies. And if a single parent family has one working for 72 hours or more, they would be entitled to certain allowances, and if they have worked for more than that, they will be entitled to other allowances. So I think these allowances are actually dispersed with reference to this proposed 468 requirement. So I definitely support this bill. Thank you.
Dr. Ngan Min Yu. Madam Deputy, I speak in support of the Employment Amendment Bill 2025. The past 2 terms of government have been doing studies on the requirement under the continuous contract. The Labour Advisory Board, LAB, was consulted on the relaxation of weekly hours to 16 hours and a lower number of a total number of working hours. Afterwards, there was another extensive discussion. October 2022, Mr. John Lee, the Chief Executive, restarted the review. With a concerted effort of various parties, there is a consensus reached. This is the 468 option. This provides better protection to those working part-time and has struck a balance between the welfare of employees and the benefits and the interest of employers. I thank the different parties involved for their work. The concept of continuous contract comes from the Employment Ordinance enacted in 1968. The aim is to offer protection to employees. The original requirement was that they will have to work for no less than 6 hours over 3 days over a period before they enjoy certain benefits. In 1990, there was another revision. There needs to be employment of 4 weeks, working no less than 18 hours per week before they can enjoy statutory holidays, sickness allowance, and pay annual leave. It's been 30 years since the last revision. There has been a lot of loopholes. Some employers deliberately make arrangements for their employees to work for 17 hours a week or once every 3 weeks, they will have to be on no pay leave for 1 week in order to circumvent the requirement. That is especially serious in certain sectors, say, for example, cleaners, security. Between October 2019 to January 2021, about 230,000 employees that don't meet the 418 requirement. This accounts for about 6.9%. There is a change in situation. Many people work on a part-time basis. The 418 requirement does not take into account the change in times. It will eat into the benefits of freelance workers. Continuous contract is a core concept. Times have changed. Improvement is inevitable. I was a member of the Bills Committee. I am glad to learn that a consensus was reached, and this proposal was supported by the LAB. The weekly threshold and the consecutive 4 weeks requirement were maintained. This will be conducive to stable employer-employee relationship. This is also very clear. 98% of the SMEs will find it easy to adapt. There is also a counting unit of 4 weeks. If there is a week that you work lower than the threshold, it may not have an impact on protection. There is a dual track approach. Weekly 18 is still used. And if there is a week when you work less than 17 hours, then the new option will kick in. This ensures that those under the 418 requirement will not be affected. Employees still enjoy paid annual leave as well as statutory holiday pay. There is a change to Schedule 1 so that more employees will meet the new requirement for better protection. The cost to circumvent the compliance is increased. This is conducive to the protection of rights of employees. In a gradual way, the benefits of employees are improved. There are still limitations, though. When it comes to people who work for a small number of hours, there is still insufficient protection. Yes, the new option lowers the threshold. But for people who work irregular hours or an irregular amount of hours, the 468 requirement will still not give them any protection. Some people work hours are affected by the season. They are not protected. The other thing is the risk of circumvention. Employers may shorten working hours or change the work arrangements. They may require employees to work less than 68 hours. This is particularly serious in low-skill work, especially work nature that is transient. There needs to be a monitoring mechanism in place to ensure that employees meet the 468 requirement. However, the onus is on SMEs. This is a burden. If there is not sufficient resources to ensure enforcement, it will be difficult to monitor compliance. Well, we have change in the work pattern. Some people don't just work for one employer. They don't work regular hours. The new requirements still fail to cater to the new form of work. In order to enhance the effectiveness of the new requirement, I have some suggestions. First, enhance the monitoring and enforcement mechanism. The Labour Department should put in place a more vigorous monitoring mechanism by requiring employers to submit proper work records. There needs to be a report hotline put in place. Support should be given to SMEs to adapt. More reference materials, templates, forms should be made available for the SMEs to comply. There can also be training courses, guidelines, more publicity and education to help employers to comply with the new requirement. In relation to new forms of work, there should be dedicated policies put in place. I learned that there will be proposals to improve the rights of platform workers. There should be clear legislation setting out the rights, benefits, and status of platform workers. The regulation of platforms should be enhanced. There should be a licensing regime put in place. There should be safety guidance, work under inclement weather, third-party insurance, as well as application procedures for delivery workers. The government should also put in place a regular review mechanism, say for example once every 2 years, to gauge the effectiveness of the new requirement. And they should also look into feasibilities of other alternatives. Different parties should be involved as well. This is to ensure that policy will cater to the changes in the employment market. The new requirement is an important milestone. It answers to an increasing demand for better protection. It has also balanced the interest of employers. More part-time workers will be protected. The government should continue to monitor the implementation and, if necessary, launch supporting measures. I so submit. Mr. Tan Yue-hang. Thank you. I speak in support of the Employment Amendment Bill 2025. There is the requirement of continuous contract. It's been decades since they were last reviewed. Some requirements are abused. Loopholes are used by employers to circumvent the system. The original requirement also fails to cater to changes in employment market. There is a need for review and amendment. We have to promote the healthy development of the employment market. Casual workers does not mean that they don't deserve any protection. The working hour threshold is changed. It's changed to 468. The weekly threshold has changed from 18 hours to 17 hours. The counting unit is changed into the total working hours of 4 weeks. If an employer works less than 17 hours, then a total of 4 weeks will be taken into account when it comes to the calculation of number of hours worked under the continuous contract. More employees will meet the requirement. They will be able to enjoy further protection, say for example statutory holiday pay, annual leave, sickness allowance. About 11,400 employees who are working on a part-time basis or irregular hours will be protected. The number of employees, there will be more employees benefiting from the revision. Those who work for shorter working hours will get better protection. I'm talking about those working on part-time basis, working as a replacement or on a casual basis. This has struck balance between the needs of the employers and employees. This will tap into potential labor force. This also is conducive to the healthy development of the labor market. The amendment is to enhance protection to employees. However, there may be unintentional problems. The government needs to be forward-looking and address these issues. I have some suggestions to make. First, There needs to be enhanced monitoring. Publicity needs to be stepped up. I don't rule out the possibility that some employers will devise a certain work arrangements for their employees to work less than 68 hours over 4 weeks. Say, for example, no more than 67 hours. In this way, employers can still circumvent their responsibility, can still evade their responsibility, whereas employees are unable to enjoy the additional benefits. I hope that the government will step up publicity and implement the law more vigorously. We need to prevent circumvention. The government also needs to monitor the implementation. Data should be collected to gauge the effectiveness of the revision. If necessary, a review should be conducted, and if need be, the threshold should be relaxed further. My second suggestion is to enhance communication and discussion between employees and employers. And there should be measures put in place to ensure smooth implementation. The revision enhances labor protection, but at the same time, it increases the compliance cost. Faced with a rising operation cost, more care should be given to ensure that there is a cordial employer-employee relationship. We want to avoid disputes. At the moment, employers are still faced with the pressure from the cancellation of the abolition mechanism. It is inevitable that operating costs will increase. In a way, employers are forced to take stock of their operation and may make changes. The government needs to monitor the changes and put in place support measures. We need to ensure that the amendment will be effective as planned. We need a more equitable labor market in Hong Kong. We need to continue to improve the employment ordinance for it to cater to changes of the times. This should also change with the change in the employment situation. For those who do not meet the 460 requirement, there are some suggestions to make changes. There is no merit in these suggestions. However, the government needs to continue to make improvements. I suggest that the government draw reference from other jurisdictions. If necessary, introduce a benefit on a pro rata basis. It's not all or nothing. This is a rigid division. We want our employment ordinance to be more flexible to cater to the different modes of employment, I so speak.
Mr. Stanley Ng. President, the FTU supports the Employment Amendment Bill 2025 introduced by the administration. This is a very significant and meaningful move. This is how we can engage the community in protecting labor rights and benefits. We have delivery workers and platform workers whose benefits have been undermined. We think that this amendment does not come easy. When I was a member of the Labor Advisory Board some 10 years ago, we had been discussing this topic. But as many employers impose pressure on the administration, that's why the government at the time did not have the courage to amend the ordinance. Finally, the administration is amending the continuous contract requirements in order to protect the employees' rights and benefits. We are amending the 418 requirements and its calculation. The relevant calculation will be amended to the 468 requirement, setting the 4-week working hour threshold at 68 hours. The statutory holiday pay is also adjusted under the Employment Ordinance. This is to address the demand of the labor force and the FTU. Many loopholes have been plugged so that more employees were able to enjoy more benefits and rights. In the past, there have been some employers who try to circumvent the 418 requirements by asking the employees to lower their working hours to less than 18 weeks in the last week in such a way that the employees were not able to meet the 418 requirements, undermining their rights and benefits. Under the amendment, the aggregate working hours for 4 weeks will be used as the counting unit of 68 hours. This will enhance the protection for employees. According to the government's estimates, upon amendment or implementation of the new bill, the additional annual cost on business will be around $0.15 billion, representing only 0.02% of the total payroll and expenditure in Hong Kong. There are some 200,000 employees who are not working under the continuous contract. Although the new requirement will benefit 11,400 more employees, there are still part-time workers who are excluded. There is still room for improvement in terms of labor rights protection. The Labor Advisory Board has reached a consensus on this arrangement. This is how we can improve the protection for employees so that more people will join the labor market to unleash a labor force. This will alleviate the manpower pressure of employers as well. This is a win-win situation. To ensure that the requirements will be implemented very smoothly, we believe that the three parties should work closely. Upon implementation of the bill, the administration should enhance publicity and promotion to enhance people's understanding of the new requirement. At the same time, we must step up monitoring so that employers will not try to circumvent the requirements. The administration must monitor the market situation and collect data to assess the effectiveness of the amendment. The administration should also review the new requirement regularly to see if there is room for us to relax the threshold. There are many freelancers and delivery and platform workers who are not entitled to the rights and benefits under the continuous contract requirements. Lastly, I'd like to say that the FTU fully support the Employment Amendment Bill 2025. Mr. Chao Xiusheng. President, the labor force has been asking the administration to relax the 418 requirement. We are only one step away from the passage of the bill. I'm glad that the employers and employees were able to reach a consensus, and I thank the administration for their assistance. In 2013, Mr. Stanley Ng and I were a member of the LAB. We discussed the relevant topic together with the administration. The Labor Department proposed 5 suggestions. one, canceling the continuous contract requirements altogether, or use the 4-week as a counting unit for the threshold of working hours. In the end, we were not able to reach a consensus, unfortunately. I was a part of the discussion, and I recognize how difficult it is for us to come to this proposal. The employment ordinance was established in 1968 in order to protect employees who work on a daily basis. Employees have to work for 4 weeks and continuously and work 3 days, at least a week, in order to be eligible for the benefits and rights. In June 1919, the government amended the relevant ordinance to enhance protection. 35 years have been passed since then. The market situation has changed significantly. I think that this bill comes a little bit too late. The reason why we want to relax the continuous contract requirement is that this is the criteria for which the employees will be able to enjoy statutory rights and benefits such as paid annual leave, sick leaves, so on and so forth. Through devising special working arrangements, employers are now able to circumvent the provision of employment protections and benefits for their employees. There are 2 major amendments to the ordinance under the bill. First, we're going to lower the weekly working hours threshold from 18 hours to 17 hours, and even if the employers work less than 17 working hours in a week, as long as the sum of the working hours of that week and those of the 3 weeks immediately preceding that week reaches 68 hours, the relevant employees will still be considered to have met the continuous work contract requirement. However, technically and theoretically speaking, there is still a way for the employers to plug the loophole. Through adjusting the working hours, the employers are still able to circumvent the provision of benefits and rights, but the cost of doing so will be increased upon implementation of the bill. We cannot rule out the possibility of employers still trying to take advantage of the loophole, but I don't think that we will see that many of such cases. I'm glad that the administration is making progress. By implementing the 468 requirement, approximately 11,400 more employees will benefit. As the FLU has said previously, we think that we should relax the requirement further. We should adopt the 460 requirement instead of the 468 requirement, such that there will be less chances for employers to circumvent the requirement and that more employees will be able to benefit. For statutory paid holidays, I think that this is basic protection. For workers with shorter working hours, they should be able to enjoy such benefits as well. If you look at other Asian countries such as Singapore and South Korea, they don't have continuous contract requirements. Part-time workers are also entitled to paid maternity leave and paid statutory holiday. But the pay is calculated in accordance with the number of their working hours. I know that we should not compare Hong Kong directly to these countries, but I think that the administration should take a step further to protect employees. This is a good starting point. I hope that the administration will make another review very soon. The administration should monitor the implementation of the 468 requirement to see if there are any new tactics deployed by the employers to circumvent the law. Thank you. I so submit in support of the Employment Amendment Bill 2025.
易志明議員。
Mr. Frankie, Deputy President, we have the administration proposing amendments to the employment ordinance to lower the weekly working hours threshold from 18 hours to 17 hours. We have the 418 requirement relaxed basically, and there will be an alternative calculation method of using the aggregate working hours in 4 weeks to be 68 hours. It is said to be a minor adjustment to provide better protection for employees, but the Liberal Party thinks that that will increase significantly the operating costs of MSMEs. And for industries with acute manpower shortage, such as franchise minibus trade, there will be a significant burden. So we have reservations about amendments. And for green minibuses, we have seen an especially bad manpower shortage. They have had to engage part-time or casual drivers. They will work 2 days per week, 8.5 hours. So altogether it would be 17 hours. Before the amendments are to come into operation, they will not be entitled to the statutory employee rights, but after the amendments, they will be entitled to statutory employee rights, and there will be at least a 20% increase in operating costs for the trade according to their estimates. This is only exacerbating the challenges faced by the trade at the moment. We have had expansion of other transport options. We have seen less people taking green minibuses, and after the pandemic, the pace of recovery is slower than expected. We have more people shopping northbound. We have less people in Hong Kong during the weekends and during the evenings. So we have seen less people frequenting the green minibuses, but green minibuses are operated at fixed frequencies. So they need to continue to run their services with the increase in operating costs. Some operators cannot have revenue that can cover their costs, and when they ask for price adjustment, the government would not allow for the increases they ask for various reasons. It is very hard for the trade. The work of drivers is hard. We have seen challenges in attracting young blood to join the industry, and we also have an aging driver population. The average age, the addition of the ages of drivers can reach as much as 200. It is a bad situation, and we have also seen some of the drivers who are unable to become full-time drivers due to various commitments. We have seen the weekly working hours threshold decrease by only 1 hour, so altogether it would be 4 hours per month. It may seem like a small change, but it is not really. For the trade, it is going to significantly increase manpower costs. Some operators can't help but to ask for a cut in certain lines, especially lines to remote areas, and the frequency has to be decreased, especially during rush hours. And for those who have worked for 68 hours in a 4-week period, they will be entitled to statutory benefits in future. With the increase in such costs, the operators can't help but cut the hours of replacement or substitute drivers. They need to hire more people in order to cover that gap. And before, we have had labor importation, and we have an 800 place quota for importation of minibus drivers. And it is said that the cost for hiring imported drivers is actually higher than hiring local drivers. It is because that they don't have enough local drivers. They have to import drivers to provide stable services. But we still are 20% short in the number of drivers. We have more drivers retiring. The threshold being lowered for working hours will exacerbate the situation. I hope that the government can therefore relax the quota for importing drivers to alleviate the burden on the trade. The government can also put in place a regular price adjustment mechanism, also reviewing the license fees. And right now, each seat would cost $400 odd, and this is a significant burden in terms of a license fee for the trade. So I urge the government to lower the fees to a reasonable standard. Apart from relaxing the continuous contract requirement, we have seen the government introduce various labor policies. We have, starting from 1st of May this year, the abolition of MPF offsetting arrangements. We will also have review cycles of holidays being lowered to a year. We also have now more holiday days. In general, we are trying to protect labor rights, but then for the green minibus trade, for example, it can be very hard for MSMEs to transfer the costs. Mr. Chao Su-chung said some of the employers are trying to circumvent the requirement, but that is neglecting how the nature of businesses can be vastly different. And why are you trying to make it difficult for businesses to survive? It may be a minor adjustment, but there are implications for the minibus trade and other trades. So I can't really support this bill. I so submit. Mr. Lo Chung-hong. I speak in support of the Employment Amendment Bill 2025 to amend the definition of continuous contract requirement. As Mr. Chao Su-chung said, the definition was established in 1968. It was last amended in 1990. So before, the continuous contract requirement would be called for 18 requirement because it would involve 18 working hours per week for 4 weeks. And we have seen employers exploiting a loophole of not having one work for the 4th week, and that would mean that those workers are not entitled to statutory rights. But I would say this. It is only reasonable if you take into account the average working hours of the employee. Now, for the employee, it may be the case that they want to work for more hours. So for 3 weeks, they may have worked for 20 odd hours, and for the last week, they would work for less than 18 hours. And the statutory rights would include, say, annual leave, sick leave, maternity leave, etc. So it would be seen as employers circumventing the requirement, exploiting the relevant loopholes, and not giving the protection that employees are entitled to. I would say that the proposed amendments are well justified, and many bills of the government in this term would be appropriate in fixing these situations. I have worked in the labor sector for 20 odd years. I have served the various districts for 20 odd years as well. I found that a lot of workers are not well aware of the relevant provisions. So they did not understand how daily wage workers or weekly wage workers would also get leave days. And it is only when they were about to leave their jobs after working in those jobs for 10 odd years that they would know that they should have been entitled to such rights. And it would be too late for them to seek such rights, seek compensation for such rights, because the statute of limitations is 6 years. And I think this shows how employees have limited awareness of the continuous contract requirement. I think the government should take this opportunity to enhance publicity. I before observed there might have been a lack of promotion by labor organizations, so I think the government needs to work with labor unions to promote the new definition of the relevant requirement. We have some people who have forced self-employment, and we will see 11,400 people benefited with the relaxation of the requirement, and the overall potential additional annual cost on businesses is just around $0.15 billion. It is insignificant in Hong Kong, but you can't help but see some employers who may want to take advantage of just saving an extra dollar. And you have seen subsidized homes who would engage intermediaries to hire care workers, and the care workers will sign service contracts, so there is no employment relationship. And we have seen the Health Bureau engaging nurses in the same manner during the pandemic. We should not have the government accept this arrangement. And I know that there has been some publicity campaign on self-employment and employer-employee relationships, but I think it is still not enough. If there are unfair employment terms, one should not accept them. Sometimes there are sudden changes in the contractual terms. One was assigned to work in a certain place, but then they are given a new contract. And for workers, it is very unfair. They can't help but accept such terms because they need the work. Should they go to labor tribunal every time this happens? Can they even argue with employers? Do they have the knowledge? We need to do more in publicity and education relating to forced self-employment. Lastly, for the proposed amendments, it benefits not only employees, but the general society. The amendments should encourage motivation, or should encourage more workers to work. And we have the relaxation of 418 requirement, providing more benefits to workers, so workers are more likely to rejoin the labor force. And with development of society, if we are striving for high quality development, there should be a win-win for everyone. We can not only aim for cutting costs to develop, we should aim for high quality development. And we need to have additional policies for industries to support SMEs. They should not think about only cutting labor costs. The government, as a capable government, should provide more support to the SMEs, in addition to strengthening labor rights. There is always room for improvement in enhancing labor rights, though. There are still some loopholes that may be exploited with the proposed amendments. as another member said, right now the definition is just for the period of 3 weeks next preceding that week. But then, if in certain situations, it may still be the case that employers can cut the hours to circumvent the requirement. And in certain cases, when the 68-hour threshold is not met, could there be a pro rata basis for the calculations so that some benefits can still be provided? I think we have to understand in future there are many challenges. There is AI. We may see a cut in working hours. So I hope the government will conduct a review in the near future to improve the relevant arrangements so that we don't have to wait another 35 years. I speak in support of the Employment Amendment Bill.
主席，
Dr. Tik Chi Yuen, Madam Deputy, over the years we've been criticizing the 418 requirement under the continuous contract is an exploitation. Now we have the Employment Amendment Bill 2025. The main amendment is to change the 418 requirement to 468. That is, over 4 weeks, the threshold is changed from every week 18 hours to over the four weeks 60 hours. This is a step forward. This reflects better the latest employment situation. The significance of this amendment provides a flexibility and affords more employees with benefits, say for example, employment protection as well as paid annual leave. This helps those working on a part-time or casual basis. It also helps to prevent the possibility of employers plugging loopholes, say for example, arranging for 17 hours work per week. However, there are still some inadequacies. With the amendment, even with the more flexible 468 requirement, there is still a possibility of abuse. Employers may make arrangements for the employee to work for 67 hours over the 4 weeks to circumvent the system. It's just like currently, part-time workers can only work for less than 18 hours a week. The government should enhance monitoring and enforcement to avoid circumvention by 467 in order to better protect employees. Currently, a unit of working hours is used. It protects permanent workers but not for part-time or freelancers. The work environment and employment situation changes. There is only one less hour required per week. This may be a step forward, but there is minimal improvement in employee protection. The government should seriously cancel the requirements under continuous contracts so that employment benefit should cover all employees. There is now a new employment situation. Employer-employee relationship has changed. Setting up a comprehensive framework for all employees should be considered. There are more and more people working part-time, working as a freelancers, working for different employers. Their welfare has been ignored. We draw reference from other jurisdictions, say Australia. They have offered protection to freelance workers, covering minimum wage, injury protection, etc. Delivery workers, carpool drivers, those working on platforms are not protected because they don't fall under the conventional definition of an employee. But they have made great contributions. They deserve protection. There are successful cases in other jurisdictions. Say in Spain, there is an act defining delivery workers as employees. They have the right to enjoy social benefits and other benefits. There is a similar act in the UK. There is injury protection as well, accident protection as well as minimum wage. This has struck a balance between flexibility and protection. We need to consider a dedicated piece of legislation to fill the gap. We need to offer basic protection to this group of workers. We need to preserve the flexibility of their work to meet the requirement of operation of platforms. There is no collective bargaining rights in Hong Kong. It's very difficult for employees to fight for their rights. Say, for example, for entertainers in Hong Kong. In 2022, in the Mirror concert, the dancer who was injured was not given full protection. The case shows that there is a lack of support and protection. A lot of these entertainers work as self-employed employees. They don't have employment benefits. When they get injured, they will have to rely on private agreement. There is no guild or no unions for Hong Kong for practitioners in the show business. In the US, they have guilds for actors and dancers. They fight for the welfare of their members. There is a step forward given us 468 requirements. This will be conducive to releasing potential labor force by encouraging more people to join the work market. At the same time, we have to monitor the changes brought by the amendment. The new requirement is an improvement, but let's not stop there. The amendment is an important step towards the protection of workers, but there is room for improvement. We need to improve the overall framework to cover workers working on a casual basis. That includes platform workers and people working in the show business. They need to be respected and protected. I appeal to the administration to make use of this chance and draw reference from overseas experience to build a more comprehensive framework so that our protection will be more progressive. Mr. Peter Shiu, Madam Deputy, congratulations to the legislators for the labor sector. They have won this battle. They have won this battle. Over the years, I have been saying that we would like to have better laws to protect employees. It would be great if everyone enjoys the salaries of tens of hundreds of thousands of dollars. But will it be viable for employers? Over the years, there's an increase of paternity leave from 3 to 5 days. Statutory holidays increase from 12 to 14 days now. Starting from the 1st of May, there was the abolition of the offsetting mechanism. That means businesses will have to put in more to pay severance pay and long service payment. When it comes to the statutory minimum wage, now it's $42.10. And the review is changed from biannual to annual basis. And if there is a full portability of MPF, that means employees will have more power and more flexibility to decide where the money goes. And all these have been successfully fought for by the labor sector. Well, the additional 4 weeks pay for maternity leave is shouldered by the administration. And there is also the ex gratia payment has been increased from $100,000 to half of the first $200,000 starting from this year. thanks to the government. And that's also thanks to the labor sector for their efforts to fight for the benefits of employees. Now we have a change from 418 to 468. I will elaborate a bit more, just like my fellow legislators. There are full-time workers, full-time employees, and part-time employees. For full-time ones, you have to give them additional benefits, say, for example, severance pay, long service pay, pay annual leave, sickness allowance, statutory holiday pay. This is to encourage employees to become full-time employees. Why is it that if you are not a full-time employee, you don't get these benefits? Well, if these are afforded to part-time employees, it may be an unbearable burden on enterprises. For full-time employees, they may think, why do you enjoy the same benefits while working shorter hours? So a line has been drawn. The line is drawn at 418. That means someone working for 4 weeks and for each week working for more than 18 hours then is an official employee of that enterprise, of that business. Some part-time employees said that they work hours. If it's an 18-hour week, that means they work for 4.5 hours every day. They are treated as colleagues. For someone who works maybe 2.5 days every week, they are treated as employees as well. You don't have to work for 1 whole year. Well, if you work on this basis over 1 month, then you have earned the status as an actual employee. The adjustment from 18 hours to 17 hours is something that I agree with. After all, the last change was a very long time ago. What I'm trying to say is that you have lump the number of hours of work together. Say, for example, well, if you work 10 hours a day, you only have to come here for, say, 3 days. I don't have to see you for the rest of the time, and you still enjoy the same benefits. What is the difference? For non-full-time employees, that is, though not working for 418, or those who are working 68 hours, what do they get in addition? They will get severance pay, long service pay, paid rest day for severance pay, as well as a long service payment. You know what the calculations are. Rest days. Currently, if you work for 7 days, you earn 1 rest day. For those working part-time, if they work for 2 days and they're given 1 rest day, that means they work for 2 days and get paid for 3 days, whereas the others, they work for 7 days and only get 7-day pay. The new calculation, the new formulation is that you don't have to work every single day. It's very easy for someone to meet the requirement. Say, someone who works for 68 hours over a month. That means the person works 10 hours for 7 days. Then the requirement is met. The person will get annual leave, sickness allowance, holiday pay, rest day pay, maternity leave pay, severance pay, and long service payment. Say someone working $15,000, someone working in the retail industry working for 20 days, that means about $750 per day. And for someone who's working for 7 days, 750 days, that means the person will get about $5,250. if that person is paid $5,250, that is it, because there is no paid rest day. However, with the amendment, the person will receive one additional paid rest day. That means over 4 weeks, you have to pay that person $3,000. That means the person working for 7 days only will receive, instead of $5,250, $8,250. And there is no restriction that the person working part-time cannot work for someone else. If someone working for 7 days at company A receiving $8,250, if that person works for 21 days, that means 3 times 8,250, 24,750 in total. That is for someone working on a part-time. The pay would increase from 15,000 to 24,750. On top of that, there is severance payment and long service payment. And if that person works for several employers, then he'll receive the payment from several employers. In terms of annual leave, a full-time worker will get 14 days. But if for someone working for several employers, they will get, say, 42 annual leave. The paper says that the additional expenditure will be 0.02% of total payroll expenditure. However, for those on a high payroll, the impact is 0. However, for micro and SMEs, they will have to pay that additional cost. So is it actually 0.02%? I give you these figures, Secretary, because my concern is that if you work full-time, you enjoy additional benefits, but now the threshold is lowered. The situation has changed. For 4 weeks, if you have to be there every week, it's very difficult for that person to switch jobs. Now, with more flexibility, it's very easy for someone to go to different places to work. You enjoy a higher pay if you're working part-time, so it will be very difficult for businesses.
Ms. Judy Chan. Thank you, President. We are now amending the 418 requirement of continuous contract to 468 under the Employment Amendment Bill 2025. That's the consensus reached by multiple parties in the Labor Advisory Board. So the New People's Party will support the passage of the bill. The concept of continuous contract was in place since 1968 under the Employment Ordinance. It has been adopted for quite a long time. The requirement is that as long as you meet the 418 requirement, you will be entitled to statutory holiday pay, annual leave, sickness allowance, maternity, paternity leave, long service pay, severance payment, so on and so forth. However, grassroots employees may not have sufficient understanding of the new requirement. That's why the administration undertake that they will step up publicity and promotion. On top of existing channels, the administration will leverage channels such as industry-based tripartite communities, human resources managers club, trade unions, and chamber of commerce to carry out extensive publicity and promotion. After adopting the new 460 requirement, not only working women will benefit because they have to take care of their families. Their working hours before the amendment may not meet the 418 requirements. Upon amendment of the ordinance, these working women will be entitled to multiple employment rights and benefits. I agree with what Mrs. Regina Ip said. I think that the administration should explain the new definition to women's organizations and groups. I hope that the Secretary will consider it. To enhance women's participation in the labor force, we should not just fully rely on the new 468 requirements. According to the statistics of CNSD, there is great potential for women's participation in the labor force. According to the 2019 study, there were 100,000 women aged between 15 to 59 who are economically inactive. There are some 60,000 to 70,000 people that indicate that they will be willing to take up jobs if they are being offered suitable employment. And they include female homemakers. So I think that the administration should set up their efforts to support women's participation in the labor force to unleash their potential. That will allow us to alleviate the manpower pressure in the market. Upon passage of the bill, I think that our next step should be, as mentioned by the administration in the BC meeting, enhance women's labor participation rate. The quickest way for us to achieve that goal is to enhance our child care service. We already have the community nanny program, which has been very successful. On the mainland, they are also offering community child care service with a different name. They not only provide child care service for women and families in the neighborhood, they also offer centers in each district. However, in Hong Kong, the community nannies work in the homes of the families with children. If we can increase the number of childcare centers, we will be able to unleash a women labor force and encourage them to participate in the labor market. President, I speak in support of the amendment. Mr. Benson-Look. Madam Deputy, I am a member of the Bills Committee on Employment Amendment Bill 2025. I participated in the scrutiny of the bill. The bill seeks to amend the ordinance to amend the continuous contract requirement and to lower the weekly working hour threshold, as well as to adopt a counting unit as an alternative of using the aggregate working hours in 4 weeks. I think that a harmonious employer and employee relationship depends on in-depth discussion and communication. Now we are changing and replacing the 418 requirements with the 468 requirement. This is how we strike a balance between the interest of employees and the burden of the employers. As I said in the Bills Committee meeting, the global economic outlook is gloomy, and we are faced with multiple challenges in Hong Kong as well. We are worried that by amending the contract requirement, there will be pressure posed on micro, small, and medium-sized enterprises. That's why I ask the administration to monitor the operation of these micro, small, and medium-sized enterprises in the 6 months after implementation of the amended ordinance and consider providing timely support to these enterprises. Although the administration said that there is limited impact on enterprises upon amendment of the ordinance, they should still have regards to the challenges faced by the business and sector to strike a balance between the survival of the enterprises and the interest of the employees. The administration expects that we will be able to unleash labor force by amending the continuous contract requirements. But from the perspective of employers, if we have more manpower, then we can alleviate the pressure. I asked the administration what sectors will see their manpower crunch alleviated, and I hope that the administration will keep in view the labor supply in various sectors and to conduct study on relevant industries as well as maintain liaison with enterprises. We have to protect the interest of employees. We also have to ensure the competitiveness of the business sector. Only with both parties win can we ensure the stability of Hong Kong.
Mr. Edmund Wong. Deputy President, employers or employees would not have an unhealthy relationship where one would benefit off of the other. It is a mutually beneficial relationship, and we need to make sure we have regard to operations of business when we make any adjustments in our policy, because we don't want businesses closing. That will result in lose-lose in the end. We have 360,000 SMEs in Hong Kong. It is 98% of the total number of enterprises. They engage 43% of our working population. SMEs are the foundation of our society, but they are faced with multiple challenges: geopolitics and the tariff wars. Even though we have put in place some measures to support them, but it will take time for the measures to take effect. We have seen changes in consumption patterns. So many of those in the retail and F&B industries are suffering. And in fact, this Monday, we have a large caterer saying that they have seen a profit loss or a profit decrease of 1/3. So is it really time for us to improve labor rights right now? We have, since last month, the abolition of MPF offsetting arrangement come into effect. We have seen some fast food restaurants closing, and many times the administration said the MPF contributions before 1st of May this year can still be offset. It is only the contributions after that cannot be offset. So the tune of the administration is that the employers will not benefit from firing workers after 1st of May. But you have to understand, when employers are faced with uncertainties in future, or they are faced with much pressure, they would think about cutting manpower first, or maybe even closing down their businesses. This bill is about relaxing the continuous contract requirements so that more part-time workers will meet the threshold and they will be entitled to the statutory employee rights and benefits. And it is said that the increase in the annual cost of businesses would just be 0.02% of the total payroll expenditure in Hong Kong. But this is still a burden on companies of Hong Kong, especially startups. Say startups, they operate on essentially a pilot basis, and they would hire workers on a part-time basis, and if their operations are viable, they will convert the part-time workers to full-time workers. With this relaxation in the continuous contract requirement, this may be a consideration for them in future. We have now more people working different roles. They are freelancing. They do not work full-time. With the amendments in the bill, the employers may offer less of such roles, so these slashers may not be able to work different roles at the time. So this may cause these existing workers to suffer. Deputy President, I understand that these arrangements, such as the amendments in the bill or the abolition of MPF offsetting arrangement, would take some research before they are implemented. So there is often a lag that when it is actually implemented, it may not tie in well with the current economic situation. So I asked the government to have in view the then economic situation when implementing the provisions of the bill. I also asked the government to reconsider implementing the MPF contribution arrangements at the end of the year. You should have regard to the economic circumstances and SME's operational situation, perhaps hold the implementation and give them some briefing room. Thank you. Mr. Kong. Deputy President, as a representative of the labor sector, I must speak on the bill. Often when it comes to labor disputes, we need to first ask the question whether only full-time workers are entitled to protection. But in law, there is no such distinction between full-time and part-time workers. Essentially, it is only with the continuous contract requirement there is a delineation. And this is essentially a threshold set by the employment ordinance. Let me say this. In different papers of the government, there is a definition of full-time workers. For employment allowances, for one working 30 hours or more, one would be seen as a full-time worker. And we have seen in previous consultations, some of those who are importing laborers, and it would also be a 30-odd hour threshold. But these are just administrative arrangements. This is not in the law. So this is just for the public's reference. So once the threshold is met, one can argue for their labor rights. If the threshold is not met, one basically cannot say anything. So I welcome the amendments in the bill to lower the weekly working hours threshold and providing an alternative calculation method. It may sound like a minor adjustment, but it is a significant change. We have the continuous contract requirement put in place since 1968, and it was last amended 30 odd years ago. Finally, we're getting a change. This is honestly much awaited, and we have seen 2013 been discussing these proposals, and isn't it too long? We do understand the business sector has concerns, but you have to understand workers are people, and we have been talking about this for a decade, and now we finally have the proposals finalized. I think the concerns are unwarranted, basically. And when it comes to labor disputes, with the continuous contract requirement, we do see some trying to circumvent this by breaking up the work. So we would have one working for 3 weeks of long working hours, but the fourth week we would have one only working for 17 hours. But this arrangement is not actually done by many SMEs. It's mostly large employers doing this because they can hire other workers to work in place of the employees. For SMEs hiring, say, 5 people, it would be hard for them to do that. So most SMEs are engaging full-time staff. I think there will be negligible impact on SMEs. Therefore, I can see with the changes in the bill, the government is plugging loopholes. It may not be a complete plugging of the loopholes, but then I can see the government is willing to change the situation and to do something about this. And it was much easier before to circumvent the requirement, but now if companies need workers, it is hard for them to circumvent the requirements. And they would need a specific employee to arrange the roster of staff to make sure they can circumvent the requirements. For SMEs, I think it is unlikely. Next, there is a case in which some number of employees will be benefited. According to administration, it would be 11,400, and the overall potential additional annual cost on businesses would just be 0.02% of the total payroll expenditure in Hong Kong. But the problem is, as some members said, we have to attract elderly persons or women to rejoin the workforce. We need to enhance the attractiveness of work. We need to motivate them to work. But I think the current situation is actually not that bad. But the government should keep in view of the situation. If we have employers trying to circumvent the situation after the implementation of the bill's provisions, we need to do something. We shouldn't wait another 30 years to do something. Some members also said perhaps 417 would already be all right, would already be appropriate, but then we need to respect the Labor Advisory Board's consensus, and we have representatives of the business sector being appointed by the government. We have the Labor Advisory Board established by the government, and it is chaired by the Secretary for Labor and Welfare. Shouldn't we support this decision? I would like to thank another member for telling me about a piece of information related to this. But let me say this. We should not abstain from voting, or we should not vote against this bill, because we shouldn't reject the decisions made by a consensus. As for the way forward, the FTU has a suggestion. We will definitely support this bill. But when there is a change in the labor situation, or if we have to unleash more potential labor force, can we put in place a pro rata calculation method so that we don't have to argue for or against 417, 418 requirements? Let's just provide benefits on a pro rata basis. I think that's reasonable. As for what another member said, if one is working 3 part-time jobs, we need to commend their efforts. Really, if they're taking up 3 part-time jobs, we should give them an award even. If one has to work 3 part-time jobs, I don't think it is only on the part of the employee. You need to have 3 employers willing to employ the employee. And I think they well deserve the benefits. And if the employers like the employee so much, they may already hire the employee on a full-time basis. But if the employers only need a part-time worker or someone working relatively short hours, and the employee can't help but have several jobs, I think we should accept that. It's not like subdivided units, because one cannot profit from essentially having multiple jobs. So we should accept that these are different choices made by different parties. We also need to enhance publicity for both employees and employers. I think some employers and employees are unaware of the arrangement. So we need to make sure we enhance publicity for the new requirement. And we also need to conduct a review, and the government should collect feedback constantly. The labor unions will also help in this regard. We also need to make appropriate assessments. We have to understand that workers are the foundations of society, and employers are also a key player in society. But most workers are just working for their livelihood. They're not trying to embezzle money out of employers. So I hope we will all support the bill. Thank you, Mr. Dan Sloan.
Madam Deputy, I was the Deputy Chair of the Bills Committee. I speak in support of the bill. The Hong Kong SAR government is working to enhance the sense of happiness and various other sense of belongings, as well as other sentiments. In the 20th government report, it said that flexibility should be built into the employment market. Better protection should be afforded. Under one country, two systems, Hong Kong should follow suit. This amendment proposed by the administration is to change the weekly working hours threshold from 18 hours to 17 hours over 4 to 17 hours, and the counting units is changed to 4 weeks, 68 hours. If you meet the requirement, you enjoy additional benefits, say, for example, statutory holiday pay, paid annual leave, sickness allowance, statutory maternity and paternity leave, severance payment, and long service payment. This answers the proposals by the labor sector. It plugs loopholes and offers better protection to employees. Some employers worked to circumvent the additional benefits. In the fourth week of work, they arrange for less than 18 hours of work. As a result, employees can't meet the continuous contract requirement. The law is clear, but does it mean that everyone understands? The FTU has been saying that a lot of people don't understand what is a continuous contract. They think that if you're working part-time, paid on a daily basis, working on a casual basis, you are not working under a continuous contract, and hence no additional benefits. The law has been in place for over 50 years. A lot of employees don't have a good understanding of the definition. We ask that the administration produce more leaflets, make use of multimedia platforms to better explain about the new requirements. That includes the working hours threshold, the additional benefits. Employees should be educated on how to calculate the threshold. They need to be told the importance of an employee and an employment contract. There is a new counting unit, 4 weeks. This actively plugs the loophole of 418. It improves the employee's protection. However, the labor sector is still very concerned that there are other work arrangements that circumvent the system. Supervisors and employers may make arrangements for the employee to work less over the fourth week to bring down the total number of hours to under 68. There are many different variations, all aimed to circumvent the system. There are always a way when there is a will. Some employees will continue to not be able to enjoy the additional benefits. The business sector may be concerned that there will be additional cost and pressure on some business operators. I would like to say that according to administration's paper, there will be about 11,400 employees benefiting from the new requirement. The potential additional cost per year is just about $150 million, which accounts for about 0.02% of the total payroll expenditure, that is 5,000. That is a limited impact. Businesses don't have to overly worried about the impact on their business cost. They don't need to be overly anxious. Even with the amendment, there is still a large number of part-timers, casual workers that are excluded from the new requirement. The FTU thinks there is a need to improve the sense of belonging, sense of satisfaction. A more stable environment should be provided. Some enterprises, if they have a high turnover rate, then they will have to go through rounds and rounds of recruitment. That itself is a cost. This will insert a greater pressure and cost on businesses. The businesses themselves won't be able to focus on development. They will lose more than they gain. I've recently attained a 65th anniversary of a school. The school has implemented some kind of reform. Primary school students said that they love to go to school. Enterprises, whether they are micro, small, medium, or large enterprises, I hope that their employees will say they love to work for their company because they are working under a continuous contract, able to enjoy additional benefits. The bill is the result of a discussion and consensus reached by the LAB. It has significance. The FTU will support the passage of the bill. Now is a different time. There is a new mode of economy. More jobs will be on a casual basis. That means more employees are excluded from the new requirement. Hong Kong is a metropolis. It is an international financial center. Publicity is that is focused on Hong Kong as a livable city. If there can be measures put in place to offer better protection to employees, this will release potential labor force. This will work to both employees and employers. I hope legislators will support this bill. To ensure effective implementation of the new measure, I hope that the different parties will work together. The FTU is of the view that there should be more publicity, monitoring, and enforcement to guard against loophole. The situation should be closely monitored. Data should be gathered to gauge the effectiveness of the new law. We hope that in 5 years' time there will be a review to consider further relaxing the threshold to benefit more employees. I speak in support of the bill. The FTU supports it.
Does any other member wish to speak? If not, I now call upon the Secretary for Labour and Welfare to reply. Then the debate will come to a close. Secretary. Thank you, Madam Deputy. The second reading debate of the Employment Amendment Bill 2025 is resumed today. I'd like to first of all thank Mrs. Regina Ip, Chairperson of the Bills Committee, Mr. Dennis Leung, Deputy Chairman of the Committee, other members of the BC, as well as the Secretariat for their support in facilitating the smooth scrutiny of the bill. I'd also like to thank the 16 members who have spoken just now for their invaluable suggestions and support. The bill seeks to amend the weekly working hour threshold of the continuous contract under the ordinance. The current provision, commonly referred to as the 418 requirement, that is, employees being employed by the same employer continuously for 4 weeks or more and having worked 18 hours or more per week, has been in place for many years. In light of the changes in the labor market, in order to make it easier for employees to become eligible for the rights and benefits under the Employment Ordinance, the administration kickstarted a review of the regulations in 2022. Upon in-depth discussion, the Labor Advisory Board, LAB, reached a consensus in February 2024. Adopting the recommendations of the LAB on continuous contract requirements is one of the labor support measures set out in the 2024 policy address by the Chief Executive. The bill amends the working hour threshold of continuous contract requirement in Schedule 1 of the Employment Ordinance, which consists of 2 major elements. 1. Lowering the weekly working hours threshold from 18 hours to 17 hours, and 2. Provide an alternative of using the aggregate working hours in 4 weeks as a counting unit, in which a week with less than 17 working hours be counted towards a continuous employment period if the sum of the working hours of that week and those of the 3 weeks immediately preceding that week reaches 68 hours. Upon amendment, other provisions of the Employment Ordinance will remain in force. The existing eligibility criteria for various benefits will remain unchanged. Employees who already meet the continuous contract requirements will not be affected. This amendment lowers the working hour threshold for the continuous contract requirements and introduces flexibility in the calculation, which makes it easier for employees to meet the revised continuous contract requirement while minimizing situations where employees' continuous employment is disrupted because their working hours occasionally fall below the threshold in a certain week. Employees who meet the new requirements will be entitled to statutory employment benefits such as statutory holiday pay, paid annual leave, etc. if they meet the relevant conditions under the Employment Ordinance, for example, length of service. In addition, with improvement in the rights and benefits of employees with shorter working hours, more people will be incentivized to join the labor force. Members of the Bills Committee generally support the proposed amendments in the bill. In today's debate, many members have raised several concerns. First, many LegCo members from the labor sector said that they are worried that after implementation of the new requirements, some employers might circumvent it. Whenever we have a regulation and rules, there is always a way for people to circumvent it. However, we believe that with the new requirement, the cost of circumvention will be higher. As a result, more employees will be able to benefit. I agree with what Mrs. Regina Ip, chair of the Bills Committee, said. She said that many women feel unfair in the sense that their employers sometimes lower the working hours in the last week to less than 17 hours, and as a result, they were not able to enjoy the employee entitlement. That's also what Mr. Shiu said. We discussed this point in the LAB at length, and eventually we reached a consensus. That's because all the members of the LAB felt that it was unfair. Employers usually take the lead in deciding on the number of working hours and devising the work arrangements. That's why we want to enhance the protection for employees under the ordinance. Mr. Shiu Ka-fai said that if the employees were able to take the lead, then they will try their best to take advantage of the new requirement. However, in actual circumstances, both employees and employers have to work together. Under the 418 requirement, if the employees were able to have the say, then they won't be, well, they will be able to enjoy all the benefits. I don't think that any one party would be able to enjoy all the benefits. I rarely see electrical members from the labor sector try so hard to convince electrical members from the business sector to support the bill. That's why I explained this in such a detail. I appeal to Mr. Shiu Ka-fai and your party members to look into the details of the requirements. We have been talking about the details at length in the Labor Advisory Board. We've talked about the scenarios you just described. We have equal numbers of employers and employees in the LAB. Why can't some electrical members accept the proposals of the LAB? Because that's the proposals that have been agreed by both employers and employees. We worked so hard to amend the requirement in order to promote the development of our city. As such an advanced society, we have to take care of our employees. For those who work long hours for an employers, if they were asked to, say, work less or few hours in just a week, they will not be able to be entitled to employment benefits. Is that fair? We have been talking about this since the time when I was just the head of Labor Department, all the way until I become the secretary. I'm glad that eventually the employers and employees were able to reach this consensus at the LAB. Under this proposal, both the employers and employees have to make compromises. The debate today is very fruitful, but I really hope that for electrical members who have concern, spend some time. There's still some minutes left. Have a second thought on their decision when they vote later on. I hope that members will vote on the prospect of our city. Many members are concerned about platform workers. Most of them don't work as a capacity as an employee because they don't meet certain criteria. This is a new mode of working. We have been working on the issue raised by some members regarding platform workers. We have been looking into the compensation that we should accord them when they suffer from injury at work, but most of them don't work in the capacity of an employee. If they are an employee, then they will be protected under the employment ordinance. I hope that all, if not all, the majority of the members share the same goal, that is, having this bill passed as soon as possible. If this bill is passed, the enacted ordinance will come into operation on the first Sunday after the expiry of 6 months after the date on which it is published in the Gazette. This allows the employers and employees to make better preparation. In the meantime, the government will launch publicity campaigns to explain the new requirements through various channels in a simple and easy to understand manner so as to enhance employers and employees' understanding of it. The government will also monitor any changes in labor relations after the implementation of the amended ordinance. I sincerely appeal to members to support and pass the bill so that we can commence the next phase of work and allow wage earners to benefit as soon as possible. President, so submit. I now put the question to you that the Employment Amendment Bill 2025 be read the second time. Will those in favor please raise their hands? Those against, please raise their hands. I think the question is agreed by a majority of the members present. I declare the motion passed. Employment Amendment Bill 2025. The Council now becomes Committee of the Whole Council to consider the Employment